A as in Alicia, and B, Your Honor, as in Barry. C as in Colette. G as in Goldfetter. K as in Kittens. M as in Magic. P as in Perfect. C as in Colette. U as in Unbelievable. V as in Victory. W as in Wonderful.
O for objection. S for sustain. E for buffering. E for Pepto-Bane. S for slime, my friend, and you, as in what you mean. I as in I don't recall. M as in may I sleep. All the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. G for gavel slams down P, T for tell 'em anything. R for rights we stand, I for infinity. Life's a courtroom dance, keep your stances strong. With ABCs of steel, you can never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round, never gonna let me down. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. 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 Never gonna let me down.
Come on in, come on in. I know it is quite late, at least for us over here on the East Coast in the United States. But ThuggerDaily, like 15 minutes before I put this stream up, I saw ThuggerDaily had a new post, ran to it, saw right away it was a motion, and I knew it was going to be Whitaker's order. And sure enough, the short of it, you guys, is we now have an official order from Judge Whitaker that the state must return Young Thug's property by 5 p.m. this Friday. So if Nick Starro's doing a 5 p.m. Friday panel like he usually does, that's going to be a great time. And it's a 10-page order. So shout out to ThuggerDaily for putting this up late at night, making sure we knew. And a 10-page order, I'm excited. Yeah, we talked about this yesterday. A quick order is great, but a 10-pager, like you guys are saying in the chat, there might be some sass. So we'll get to see her reasoning on this. And I haven't read it yet, so this will be blind for me. We obviously have the spoiler, right? We know that the stuff's going to have to be given back. And this was submitted at the end of the business day today at 5:29 p.m. So guys, we're going to get into it. Thank you, T. Roberts, for being a member for 4 months also. But we've got this order granting a Jeffrey Williams motion to dismiss the state's appeal and motion for return of property in Stanter. So we knew yesterday from the oral order that they were dismissing the state's appeal of the other dismissal of the initial decision to dismiss the civil forfeiture case. But we weren't sure because Whitaker said she's deciding, but told the state to be prepared to return the stuff by Friday. Now we know. We have in Stanter here, which means Gotta do it now. So it says this case is before the court on claimant's motion to dismiss state's appeal and motion for return of property and stanter, filed on December 18th, 2025. And that was a great stream, you guys. Thank you guys for a great stream that day. We were all like, like, what is the state doing? The court conducted a hearing on said motion on January 6, 2026. For the reasons articulated below, the court hereby grants claimant's motion in its entirety. We're giving no bones, no crumbs, no scraps to the state here. So we've got the procedural history. On August 18th, 2025, this court conducted a final forfeiture. Final forfeiture hearing in the above referenced case. And after the introduction of evidence and hearing argument, this court granted Mr. Williams' motion to dismiss the state's forfeiture complaint. A final order granting motion to dismiss forfeiture complaint was entered on August 22nd, 2025. So, and by the way, guys, this is procedural history. It can be boring, but when we're dealing with this weird stack of like, well, wait, they're appealing a decision I thought they lost back in August, these procedural histories help us get the bullet points right. And exactly that, Just Shamrock is saying the same thing. How many times do you have to dismiss to dismiss? But this is what she's laying out here. On or about September 19th, 2025, the state filed a notice of appeal from the court's August 22nd, 2025 order. So remember, that was like the final ticking hours. They had the 30 days. The notice of appeal specifically states, quote, the state requests that the clerk will omit nothing from the record on appeal. Additionally, the notice of appeal contains the statement, quote, the state requests any and all transcripts filed into this case be sent to the appellate court as part of the record of this case. Specifically relevant to this appeal, is a transcript of the hearing which took place on or about August 18th, 2025. Prior to the August 18th, 2025 hearing, the court informed, and this is really what she's mirroring here, what Whitaker's mirroring here, is what Brian Steele and Leanne Webster laid out in the December 18th motion that we looked at. Prior to the August 18th hearing, the court informed the parties via email that the court would not provide a court reporter for the hearing, and that if the parties desired to have the proceedings taken down, the parties would be responsible for obtaining a court reporter at their own expense. Mr. Williams' counsel's office contacted counsel for the state of Georgia. I think it was Grant Rood that was handling. Grant Rood was on the receiving end of this very nice offer, professional offer from Jeffrey Williams' team. And Jeffrey Williams' team inquired if the state desired to have the proceeding taken down, and if so, whether the state wanted to share in the takedown expenses. The state did not respond to the inquiries, thus rejecting by silence. Oh! I love this. Thus rejecting by silence the offer to jointly retain the services of a court reporter. Guys, why do you think I love seeing a judge tell Fulton County, tell the prosecution, or the plaintiff in this case, it's a civil matter, so it's technically a different, we know it's related to the YSL. That's why they say that we shouldn't have to return these belongings because our theory is they were the proceeds of these crimes, and Jeffrey Williams pled guilty. So who cares if we missed our deadlines to follow the procedures we're supposed to follow? Just let us keep his stuff. Thus rejecting by silence. I love this. How many times did we hear during the YSL trial the state argue that co-conspirator statements should come in, and part of those co-conspirator statements were somebody else was saying something, and one of the co-defendants was on the line. They weren't the ones saying something, but because they didn't respond denying it out loud, the state argued they therefore acquiesced through their silence. So Whitaker is saying, hey, you know what, state? Your silence, we're going to use your silence against you here. So I love that. Anyway, Whitaker goes on here to say thereafter, the state never sought to share in the expenses of the court reporter, and Mr. Williams alone secured and paid for a court reporter to be present and take down the August 18th, 2025 hearing. If you missed the previous streams where you went through this, there's like procedures written out where if one party secures the court reporter and the other doesn't chip in, But then that party needs to ask, hey, we need those transcripts, even though you paid for it in full. The procedure would be that the party that didn't go half originally could be ordered by the court to pay the whole thing if they want to be able to get an order to obtain the transcripts. So the worst could have been they had to pay the full cost at this point. But it gets worse, and I'm sure Whitaker is going to get into it because we've still got 8 more pages. After the hearing in which the state's forfeiture complaint was dismissed on September 19th, 2025, counsel for the state asked claimant's counsel for the name and contact information of the court reporter whom Mr. Williams had secured for this proceeding. Counsel's office provided this information to the state on September 24th, 2025, well within the 30-day period in which the state was to have the transcript of the evidence and proceedings prepared and filed as to be included in the record on appeal pursuant to OCGA 5-6-42. On October 20th, so again, now we're jumping, this 30-day clock is running really from what would have been I guess she's doing the 22nd rather than August 18th. She's looking at August 22nd as the start of the clock when the written order was filed. But we're right at the final hours again here, jumping forward to October 20th, 2025. That was the last day permitted by law to file the relevant transcript. The state filed its first motion to extend deadline to file transcript and represented to this court that an extension of the 30 days or until November 19th, 2025 should be enough time for the court reporter to finish and file this transcript. The implication of this statement was that the relevant transcript had been ordered and that the court reporter had indicated that she would complete and file this transcript on or before November 19th, 2025. Especially if you've gone and asked, hey, what was their name? The court did not enter an order on the state's motion to extend deadline to file transcript filed on October 20th, 2025, as a courtesy copy of the motion was not emailed to the court as required by the court's standing order, and the state did not otherwise make the court aware of the motion for extension. On November 19th, 2025, so another 30 days forward, the state of Georgia filed a second motion to extend deadline to file transcript. In the state's second motion to extend deadline to file transcript, the state of Georgia represented to the court that an additional 60 days from the original deadline, or until December 19th, 2025, should be enough time for the court reporter to finish and file this transcript. So, how would you guys interpret this? If you received a request at work or from a friend that owed you something, and they said, hey, I'm trying to get this thing for you. And then they come and they say, hey, I need an additional 60 days to get that thing for you. You would hope that they're actually making an effort to get the thing, especially if somebody else had emailed like, hey, we're willing to go half with you and get that thing. But nope, we just ignore it. So Whitaker says again, the implication of this statement was that the transcript had been ordered and that the court reporter estimated she would be able to complete and file this transcript on or before December 19th, 2025. The state again failed to email a courtesy copy of the motion to the court as required by the court's standing order or otherwise make the court aware of the motion for extension. The court discovered the motions during a routine review of the docket and, based on the representations of the state made in the motions, this court granted the state's motion to file the transcript on or before December 19th, 2025, but specifically warned that no additional extensions of time would be granted unless for good cause. So you would think if you got that, this is go time. You got to go get those transcripts because you've asked for 2 extensions and the person giving the extensions is like, this is it. No more. No more. Subsequently, claimants filed the instant motion, noting that as of the December 18th, 2025 filing date, the state had never actually contacted the court reporter to order the transcript. And that was when I said we did that stream, we went through it all. Everything that we've read above was laid out like point for point with the timelines in the substance of the motion. And then all of the receipts were attached as exhibits. So all of the email correspondence. And then an affidavit from the court reporter like, nobody has contacted us from the state requesting the August 18th hearing. And they got that affidavit like December 18th, like the night before they filed this response. Or December 17th, right before, like, the final minutes before they file this. So by the time they filed this December 18th, which is the day before the final deadline, Brian Steele has receipts to show the court that the state has still not even tried to order the transcript. So the state had never actually contacted the court reporter to order the transcript. Claimants submitted an affidavit from the court reporter's company in support of the motion, which averred that the state had never contacted the court reporter or the court reporter's agency. In fact, and then we have a parentheses. In fact, it is the position of the court reporting company that because the state did not share in the takedown expenses, the state lacks the ability to order a transcript of the proceeding. Just salt in the wound. At the hearing held on January 6, 2026, the state stipulated that the affidavit mentioned above was true and accurate in all the details. The state acknowledged that it had never contacted the court reporter to order the transcript, despite the representation made in its two motions to extend the time for filing the transcript. So remember yesterday, I think, based on the reporting we had, it seemed like the vibe in the room was that Whitaker was not buying that the state, oh, it wasn't malicious, we didn't know, oopsie daisy. And here it is on paper. The state's only argument was that the appeal should be permitted to proceed despite the ongoing delay in transmission of the record, parentheses, over 75 days by the time of the hearing on the motion to dismiss the appeal, because it did not act out of malice toward the court, opposing counsel, or claimants. The state did not attempt to address how the delay, caused solely by the state's actions, was not unreasonable or inexcusable. So, and that's when we looked at the tweets from Leanne Webster yesterday, who was very helpful in giving us context. She said they argued that it was malice, and that's not the test. That's not the standard. That's not the argument. And I'm sorry, I still have the starting soon banner sitting at the bottom. So let's see, legal analysis. And I love this because I'm pretty sure, I forget if it was from Sylvia or maybe it was from Leanne, but we did hear that they were looking, that Whitaker asked, do you have case law on this? Like, do you have any case law to back up what you're going on about, essentially? So, of course, the judge is going to include the legal analysis to back it up, but it's just funnier when the party that's whining doesn't offer any. So she starts off with she's quoting the statute here. She's starting off with the statute, saying, where there is a transcript of evidence and proceedings to be included in the record on appeal, the appellant shall cause the transcript to be prepared and filed, ... within 30 days of filing of the notice of appeal. And this is the exact statute that Steele included in their December 18th motion. So this is OCGA 5-6-42. It goes on to quote here the same cases that were cited by Steele and Leanne Webster. The statutory duty to file timely a transcript does not rest with the court reporter. Rather, the duty to order the transcript and to monitor timely the progress of the reporter's office in transcript preparation is vested upon the appropriate appealing party. So we saw the citation to Jackson v. Beach in Steele and Leanne's motion, and this Ashley v. JP Morgan Chase Bank cite in normal course. And this is going back to the beginning of this order. I mean, this is why we're having Whitaker say, we grant the claimant's motion in its entirety. You provided an affidavit to support your statement of facts that, hey, they never reached out to this court reporter at all. Here's an affidavit that backs that up. And here's the legal analysis, the legal framework that shows that the state has no claim here, that you should dismiss this and you should order that they should return Jeffrey Williams' property immediately. And Whitaker is agreeing with the affidavit they provided, agreeing with their timeline that they provided, and reciting back the exact same citations that Jeffrey Williams' team provided them. So I think that's what she meant by in its entirety. Everything you're asking for and the analysis you're arguing backs it up. Yes. So we were left off here. Next, we have Morel v. Western Services and Pistachio v. Frasso, which I think I recognize those from the December 18th filing. In normal course, appellants are not accountable for delays caused by clerks of court or court reporters after the transcript has been ordered properly. However, appellants are held accountable only for delays that they cause. And then this cite to subsection C of OCGA 5-6-48, no appeal shall be dismissed by the appellate court, nor consideration of any error therein refused, because of failure of any party to cause the transcript of evidence and proceedings to be filed within the time allowed by law or order of court. But the trial court may, after notice and opportunity for hearing, which we had the hearing, order that the appeal be dismissed where there has been an unreasonable delay in the filing of the transcript, and it is shown that the delay was inexcusable and was caused by such party. In other words, the court may, but they have to have a hearing first, which Whitaker did. And the issue at hand was there an unreasonable delay or not? And the state, instead of saying it's not an unreasonable delay, we weren't the cause of it, they were just like, well, it wasn't malicious. But they didn't argue, they didn't go to show anything to demonstrate that it's not an unreasonable delay. So, oops. Trial courts have very broad discretion when deciding whether to dismiss an appeal for delay. We've got Kleber v. Cobb County. In cases where the non-moving party seeks dismissal of an appeal based upon the failure of the appealing party to comply with OCGA 5-6-42, the same statute, the issues to be analyzed are straightforward. 1, has there been an unreasonable delay in the filing of the transcript? And in the chat, we took a poll on this, an informal poll. Everyone was like, yes. 2, was that delay inexcusable? Do you think there's an excuse, a justifiable excuse for the state not even asking for the transcript after asking for 2 extensions? They could have ordered the transcript in the time it took them to ask for the second extension. So then you've got 3. Was the delay caused by the party prosecuting the appeal? As the court ruled at the hearing, after the state failed to contest any of those prongs, all 3 requirements have been established. First, there was an unreasonable delay in the filing of the transcript because the transcript has still not been filed over 90 days after it was due. In fact, the transcript was never ordered. And we have a footnote. Oh, what? The footnote starts by saying the state attempted an end run around the instant motion to dismiss appeal by filing an amended notice of appeal on December 22nd, 2025. They're calling out the amended notice of appeal. Oh, man. I don't know if it's the same effect if we're not able to watch Whitaker say this lie, but I think we got to throw up some flames here. And while this motion to dismiss appeal was pending, but before it had been heard, that filing disclaimed any need for the transcript. Remember, that was the state's amended notice for appeal, where the only thing they changed was they added a footnote saying, upon review, we no longer need the transcript of the August 18th hearing. And I think Jim and I went live, and we were sitting here like trying to figure out, is this real life? Like, how is this really happening? Because it doesn't matter if you all of a sudden decide now you don't want to get the transcript. You've asked for 2 extensions for it. Your initial notice of appeal stated 3 times, as Whitaker quoted above at the beginning of this order, that you specifically wanted this transcript for the August 18th hearing, and you wanted nothing omitted from this transcript when it was submitted to the Court of Appeals. And then even worse, you don't get to make that call. The statute itself says, hey, if you're going to file some type of appeal like this, you as the petitioning party should provide the record. But they filed this notice of appeal. Now we have a whole footnote about it, calling it out. So yeah, the filing disclaimed any need for the transcript and requested that the record be transmitted without the transcript. Claimants moved to stay, so this is Steele, right after that. I think it was December 30th, they came in. And they said, hey, before we have this hearing, can you stay the transmission of the record? This random notice of appeal that they filed, this amended notice, can you stay the transmission of the record pursuant to the amended notice of appeal, which the court granted until it could hold the hearing already scheduled on the instant motion to dismiss appeal? The court notes that the state's amended notice of appeal was filed 3 days after the last established deadline for filing of the transcript, and it does not appear to the court from the docket that the state ever paid the bill of costs for the appeal. They didn't pay the costs of the appeal. I think it's like $250. I don't know if anyone knows offhand. In Florida, it's no big deal, but when you file a notice of appeal, you pay like some nominal filing fee, and I don't want to call it nominal. It can be difficult for like a layperson that's trying to file their own appeal to come up with a couple $100. But what I'm saying it is, when you're the state and you're fighting this case for on and on and on and on and on, and you don't want to pay $208 to go halfsies and get the transcript when the Steele law firm reaches out to you and says, hey, we see you filed a notice of appeal, and you would be required to now pay the full takedown cost that you didn't want to go halfsies on earlier, but we're still willing to go halfsies with you. It'd be $208. They don't want it. But now they're not even filing the required fee. So this is yet another procedural, and there's no excuse. It could be a mistake. It happens. But the clerk usually says, hey, can't accept this because it wasn't filed properly. We saw that happen with Alicia Andrews. So if you remember with this, Alicia Andrews is appealing Judge Michelle Sisko's denial of the motion to disqualify herself. And they said, hey, we're sending this up to the Court of Appeals and we want to stay the sentencing while we do that. Well, they filed to the Court of Appeals and it got kicked back because they didn't pay the fee at the time they submitted the notice of appeal. And so Michelle Sisko was like, well, there's no active appeal. It was rejected. And then they go and they fixed it and it was filed properly. And then they were able to say, hey, no, properly filed. And the Court of Appeals says stay the proceedings at the lower court until we get to do our thing. It happens. But like, you would think if you're creating all of this chaos, you'd be a little bit more diligent. Like, I don't know. I feel like I could just throw my hands up and stare at this footnote for like another 2 minutes here. But Whitaker's calling it all out. So they never paid the bill of the cost of the appeal. They never ordered the transcript. Here we are. And then we get back to the argument here, the legal analysis. The question of whether the delay was unreasonable, quote, refers principally to the length and the effect of the delay rather than the cause of the delay. So that's Adams v. Herbert. Here, the claimants, so Jeffrey Williams, and they're just saying claimants. I assume this goes to anyone that might have a claim. Maybe the jewelers are still involved in this, but anybody that has a claim to what's currently unclaimed that wasn't worked out with Martinez Arnold's settlement of his portion of this case. The claimants have been prejudiced by the state's delay because the state's appeal would likely be docketed in a later term. So Steele argued this and Page is agreeing. This is extra prejudice because this appeal will now kick into the current term of court than it would have been had the state complied with its duties to timely obtain and file the transcript. This is an unreasonable delay. Just a 5-word sentence. The question of whether the delay was unreasonable. This is an unreasonable delay. And then they're quoting here from the Morell case. The 3-month delay here discernibly delayed docketing of the record in the appellate court and prevented an appellate decision on the merits at the earliest possible date. Actually, that was Pistachio v. Frasso. Morell, they've got holding that 51-day delay caused delay of appeal from one term to another. We've got concluding that 150 days resulted in delayed docketing from one term to another. These are all cites that I think I remember from the December 18th motion. Again, Whitaker's just yep, straight down the line with everything that was argued in that motion. So we've got, let's see, we've got this holding that a 4.5-month delay was unreasonable and delayed docketing in appellate court. We've got a holding concluding that delay resulted in docketing for a later term of court. And another that says holding that 10-month delay prevented the case from being docketed and heard at the earliest possible appellate term of court. I'm looking over here at chat, and Mel says, good to see you, Mel. I can't wait till Friday when they don't turn anything in. Secret Whisper says you can see why they need to scare people into a plea deal. Ridiculous. And especially why they wanted those, like the gang activity type charges to be part of the pleas. And probably why Brian Steele and Jeffrey Williams, Keith Adams, during the trial, even though Jeffrey Williams put his fate in the hands of Judge Whitaker's terms for the sentencing. That negotiated plea kicked back some of the key charges to being null-prossed. And I think that was very strategic and very smart on Jeffrey Williams, Brian Steele, Keith Adams' part. But I think that's exactly right. You get them to plead to something, and then you have this broad arching thing to point at, this disposition that, hey, we seized this stuff, and we thought it was the proceeds, or it was obtained using the proceeds from criminal activity. And then we have this disposition showing criminal gang activity. So I think that's exactly right. Just a whole mess, you guys. Just a whole mess. We've got Danielle saying they can't afford it if they can't pawn any more of his stuff. Like, just crazy. And it might be crazy to want to believe, but there's civil forfeiture issues all around the country where people, they never even get convicted of anything. They don't even take a plea deal. They're just, the charges are dropped, or they're acquitted if they take it to trial. And then they never get things like the cash that were seized from them back. Like, this idea that stuff goes missing, it really happens. So, and I don't know, Friday might be a good time. Friday might be maybe a bad time. I don't want to say it's a good time that someone doesn't get their stuff back. But I think there's a good chance that the state is sweating. Also, Danielle, thank you for being a member for 16 months. Says she took up 10 pages to malign the prosecutor. Oops. And Fulton County, they have, like, Grant Rood, his title, it's the Civil Forfeiture Unit. And I don't know, if maybe Fulton County just comes up with titles and creates units for, like, the fun of it. But still, if you have a dedicated unit for something, you would think that they would respond to emails where someone's trying to help them pursue the case. You'd think that they'd follow basic procedure, timelines, things like, hey, this is how you need to notify the court if you file something. So I don't know. I don't know what we're doing here. We've got Ike in the building saying, hey folks, more shenanigans? Yep. What else is new? What else is new? Gigi says, I was shocked to find a live stream. This is a late one. Heart of Inspiration, good to see you. I feel like it's been a bit. Hope you're doing well. Got Brooklyn in the building. Adventure Aaron says, long footnote. Could be longer. I love a good long footnote. I hate a boring long footnote. Let's see, where was I? All right, so now we're at the second part, right? We're going through the issues. So, delay was unreasonable. And then second, the delay was inexcusable. So, quote here, the ordinary signification applied to the word inexcusable. And this I love. Do you guys remember when we saw this in Steele's motion where they just cite the Webster dictionary of inexcusable? So Whitaker's using it too. Or I guess this might come from this case. Who knows? That the ordinary signification applied to the word inexcusable is that the conduct by act or omission. So remember that silence, not responding to that email, was not inexcusable, incapable of being justified. Webster's Encyclopedic Unabridged Dictionary of the English Language, 1989. So yeah, this whole definition was part of Jackson v. Beach. At the January 6th hearing yesterday, the state admitted that it has no excuse for its failure to comply. Well, at least there were a little bit of honesty here. We've got to appreciate it when we get it. To repeatedly request extensions over a period of months without making any effort, much less a diligent inquiry as to the transcription status with the court reporter or the court reporting company, constitutes a lack of reasonable justification, and the state's conduct is inexcusable. That's carbonara. Love a good carbonara dish. There, the state averred in its notice of appeal that transcripts would be included with the record for an appeal, but never ordered or paid for the transcripts. And during that time, they wholly shirked their responsibility to obtain the She's just using a citation here from carbonara. She's saying you did exactly what this precedent says you can't do. She says, and, quote, during that time, they wholly shirked their responsibility to obtain the transcript as required by law and to remain in contact with the court reporter about progress. And again, this required by law part is important because the state's idea of amending their notice was just like, upon review, we've decided for ourselves that we just don't want that transcript for the August 18th hearing. It's no big deal, so just move it along. So, which it's not their place to make that decision. So, just crazy. And yeah, thank you, Aaron, for the assist. Always love when Aaron's in the building, because I'm like, all right, 7 pages in, I'm getting lost in the citations here. Not here realizing that this definition was part of the site. So we've got, let's see. Here, the state admitted it has no excuse for failure to order the transcript or for its... She used the parentheses it still used. She did misrepresentations with the miss in parentheses that was in Steele and Leanne Webster's motion. Oh my gosh, I love this. This is like... This is spice. This is a very subtle but loud way to hand it to somebody. Oh my goodness. Oh, I would be so happy if I was Steele's team and just saw that the judge repeated exactly what I wrote in the motion. Work of art. There we go. Jersey Girl Trey with the claps. With the Whitaker face in the chat. Kay Shelton, heck yeah, cannot wait until Friday to see if he gets all of his stuff. Same. So we've got, let's see, in parentheses here that this Coptic case, let's see, Coptic not only did not seek an extension of time, so she's distinguishing how the Coptic case, the petitioning party, actually did way better than the state did here. Coptic not only did not seek an extension of time to file the hearing transcript, but apparently never communicated with the court reporter during the 9-month period between the hearing and the filing of the motion to dismiss. So not really good for Coptic there, but at least they didn't try to file an extension of time while they weren't trying to get the transcript anyway. Here, the state, Fulton County, was filing these 2 requests for extensions and also not doing this part. The state did seek the required extension of time, which is one of the factors considered in whether a delay in filing a transcript is unreasonable and inexcusable. However, the failure to ever contact the court reporter or the court reporting company to order the transcript, combined with misinforming the court, she did not believe them yesterday, and she's putting it on paper, that you made misrepresentations to this court. She is memorializing this in writing. Combined with misinforming the court and the parties in their motions, not once but twice, with the unfounded representation that with the requested extensions, the transcript would be filed, is fatal to the state in the analysis of whether the delay is unreasonable and inexcusable. And then we get this last little holding here from Mercer v. Munn that says, failure to demonstrate that delay in contacting the court reporter to order the transcript was excusable resulted in dismissal of appeal. I mean, I would love to see the state try to appeal this decision. like, forget it. Just try it. Because Paige is laying it out here for the appeals court. Again, she's really citing all of the stuff that Steele and Leanne Webster, they put in their December 18th motion. But this is like a solid, the Court of Appeals is just going to be like, boop, 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 boop. Yeah, I'm relying on you to actually be honest with the court. Oh, this is crazy. Gigi says Whitaker isn't trying to be nice anymore. Yeah, David Trailer says Fani pissing off all the judges was a bad idea? Question mark. I still shout out to McBurney. Shout out to Judge McBurney. That made my day. Just his little calm call out. And poor Adam Abadi sitting there like the blunt of the joke. Whatever the phrase is. You know I mix up my phrases all the time, but you guys know what I mean. Put Whitaker on the next album. Yeah, touche. So she's saying fatal here. And good to see you. But if you guys joined late, right in the beginning, she's like, I'm granting everything that the claimants, so Jeffrey Williams, asked for in their motion in its entirety. Like, it's just been no holding back. No holding back. All right, and I forget where we were. Mercer and Munn. All right, inexcusable. And then finally, guys, finally, we have a finally. And still a ton of celebration in the chat for the spice. Yeah, body yada yada. Steph JK shows up when we say a body. Good to see you. So we've got finally the delay was caused by the state. As to the final issue, the facts are indisputable. The state filed a notice of appeal and bore the responsibility to order any transcript of evidence and proceedings and ensure that it's timely filed. And again, they're citing Kelly v. Dawson City here, but some of this is also required by statute, like the timelines. And then the Court of Appeals process. The entirety of the delay has been solely caused by the state. Prior to the August 18th, 2025 hearing, the state rejected participation in takedown and or sharing in the expense of the court reporter. And as admitted at the hearing on the instant motion, the state has never taken any affirmative step whatsoever to contact the court reporter or the court reporting company or otherwise order the transcript. We've got Norman v. State here. It says, because Norman's counsel failed to properly request the transcript and conceded that he did not communicate about the status of the case with the trial court, the state, the clerk's office, or the court reporter after filing a notice of appeal, there was no abuse of discretion in the trial court's dismissal of the appeal. Alyssa says this is just embarrassing. Like, and twice, because they were called out by Steele and Leanne, and then they're like, oh, you know what we should do now after they laid out everything with receipts? Let's file an amended notice of appeal and just say we don't need the transcripts anymore. Like, it'll be fine. It'll be fine. Ike says, any way to FOIA Georgia for how much was spent on this case in its cumulative entirety? Have you heard about the quality of record keeping and or the quality of accounting and or the willingness to respond to public records requests in Fulton County specifically? So, that pathway exists, but I think the simpler route is just to assume way more than anyone could argue was an effective use of time and money and resources. But yeah. Oh, wait, do we have a Steele quote? Let me keep reading. Oh, this is amazing. I see it, Sophia. So let's read this next part. I think this was the flair in the motion. So there's spice, and then there's the, like, inspiring moment. And right here we have justice delayed for even 1 day is justice denied to the litigant who was successful in the lower court and who is entitled to his judgment unless the case is properly reversed. Which, again, delay is unreasonable as it caused the appeal to be docketed in a later term of court. The brunt of the joke. Thank you, 420. We've got, as shown above, there's like literally, I want to like, there are some things that, as much as I talk and laugh about like attorneys getting in trouble for using AI and then denying that they were using AI, I still think there's some fun uses for AI, and I think it'd be interesting just to plug back and forth, like, the December 18th motion and this order and just say like, hey, can you do a quick comparison of the similarities, the overlaps, and then find the differences and see what an AI says? Like, how similar is Whitaker's order to what Jeffrey Williams' team just laid out? As shown above, and it should feel like deja vu, but it's not. It's not feeling like that because it's very different to see the judge in an order repeating all of these things. So it doesn't feel repetitious in like a tiresome way. So we're getting to the end here. As shown above, 1, there has been an unreasonable delay in the filing of the transcript for the forfeiture hearing as required by this notice of appeal with a footnote. We've got a footnote, another long one, which I'm fine with. It says, as to the state's belated and arguably out of time. B for belated. The state's belated and arguably out of time amended notice of appeal. She's acting like this is like a late birthday wish. Like, please let us have this extension. Let us amend this notice of appeal. Just let us have one more chance at a birthday with these items that we don't want to return. Discussed above, the Court of Appeals has, in at least one case, found that a subsequent decision that the transcript was unnecessary for the appeal did not remedy. Oh, so I don't think, because we never had a response on this issue from Steele, but maybe this was discussed orally at court tomorrow. Maybe the Steele team and Leanne brought this case up yesterday, but this is my first time seeing it. But there's case law to say you can't just put a footnote in an amended notice of appeal to say, upon review, we decided we don't need that very critical hearing about the decision we're appealing for this appeal anymore. So here's a site that Whitaker's adding in a footnote that a subsequent decision that the transcript was unnecessary does not remedy the delay caused by the failure to timely obtain it. What a chef's kiss footnote here. The epitome of and another thing. It says, we've also got, quote, but none of the foregoing findings by the trial court are sufficient excuses under Georgia law for significantly delaying the docketing of an appeal. Importantly, after failing to file the transcripts for 5 months, the defendants waited 2 additional months after HBN filed its motion to dismiss the appeal to inform the court that a transcript was suddenly no longer necessary for the appeal. This case, whatever happened here, looks exactly on point with what Fulton County is doing with this case. They're waiting. They're not trying to get the transcripts. They're not trying to meet deadlines. And then they're just randomly changing the timeline to make up for not meeting deadlines. So beautiful footnote there. So next we have 2, that this delay was inexcusable and prejudicial to claimants, and 3, that this delay was solely caused by the state. Mr. Williams has been prejudiced as he continues to be deprived of his property. Thus, the court orders the state's appeal to be dismissed. Now we have the issue of the return of property. And shout out to anyone. I feel like there's been 3 different times that I have posted the Courage the Cowardly Dog. I almost said Curious George. But Courage the Cowardly Dog, there was an episode with the Return the Slab. And that's all I think of every time this civil forfeiture case. There's some other like, no, wait, please don't make us return that stuff. Just makes me think of that. We've got Hal, if you want to come up, I'll send you a link. Let me know. Did the state win? I mean, honestly, in a weird, twisted way, if they actually stop and give this up, I think this is great for them to finally, like, be told to move along. So obviously it's not a win, but it's like, sometimes you have a friend that's acting out and they, like, really need a heart-to-heart. Like, pull the plug out of the drain and say, like, you gotta let all this go and move on. So let's see. We've got the return of property. Right? Imagine being the state and reading all of this and then getting to the, oh yeah, the stuff we gotta return. The state is also ordered to return claimant's property in bold by 5 p.m. on January 9th, 2026 to Mr. Williams or his designee. So let's see. This is OCGA 9-16-18B. that says on entry of judgment for a person claiming an interest in the property that is subject to a civil forfeiture proceeding, the court shall, and it's Whitaker adding this emphasis, the court shall. And I think Andrew Fleischman, we read his tweets yesterday. We were like eavesdropping in on X yesterday on Andrew Fleischman and Leanne Webster's conversation. And Fleischman was like, yeah, pretty sure if the judge doesn't order the return of the property and dismiss this, that a court of appeals would actually say, hey, you made the wrong decision, judge. So Whitaker is like, yep, I've got to order that the property or interest in the property be released or delivered promptly to that person, free of liens and encumbrances. Now, this is important because we heard that yesterday the state was trying to make this weird unbalanced, they had no position to be bargaining with, but they tried anyway to say, hey, you know, if you just let us keep going with this appeal, if you let us appeal the decision that Whitaker's making today, we'll let Jeffrey Williams have his stuff back, temporarily. But you'd have to give it back if we win that appeal. What kind of offer was that? But there's no, you cannot, statute says that cannot be done. And I'm pretty sure that was the point of the hearing where Whitaker must have said, do you have any case law on that? So it's codified there in a statute. Courts are required to strictly construe the forfeiture statute against the state, as they are quasi-criminal proceedings that are disfavored by the law. And then we also have, forfeiture is a quasi-criminal proceeding that permanently extinguishes a property owner's rights to certain property, and accordingly, the forfeiture statute must be strictly construed against the state. So even though it's a civil proceeding, because it's quasi-criminal in nature, there's certain rights that are entitled to somebody that's criminally accused. So this is quasi-criminal, there's additional rights here. The court entered judgment in claimant's favor by dismissing the forfeiture complaint. Strictly construing 9-16-18b, the court finds that the plain language of the statute, there's no interpretation. It's just literally what we're supposed to do according to this statute. The court finds that the plain language of statute requires that claimant's property be returned promptly, free of liens and encumbrances. The state has not identified any authority, this is absolutely where they were asking for case law yesterday, that would allow it to retain custody of the property where the forfeiture complaint has been dismissed, and now the state's appeal of that dismissal has been dismissed. she's doing I'll put up do I have my Charlie picture ready? I don't think I have it ready. But she's doing the loop-de-loop. All of this has happened, but you got to just give it back. So even if the state were to file a notice of appeal to challenge the dismissal of its appeal, we're getting into nested appeals, there is no basis for determining that such a notice of appeal would operate as a supersedious or would permit the state to retain the property. So the only reason we have to include this is because the state was trying to figure out yesterday some way that they would still have a claim over the property while they would have to return the property to Jeffrey Williams because this was dismissed, even if they chose to appeal further. And to me, it just made no sense. I was really tired yesterday, so I don't think my brain was all there. And I'm sure you guys can see it when my brain goes to mush. I took a nap today, so I feel refreshed. I didn't sleep well last night, but I took a nap. I feel so refreshed. I feel like my thoughts are much clearer and straight. And yesterday, when all of this was happening, ThuggerDaily, Jim, I was just sitting there, and I think there was just a bit of confusion that I was hoping that they'd be able to help me iron out, but they're like, I don't get what the state's trying to do either. And it was because of this. It was because the state was just trying to act like them still maintaining some type of interest because they want to continue an appeal is something allowable. But when you're ordered to return something without liens and encumbrances, you can't also have an interest in those items. It just didn't make sense to me. And I feel very validated, and I feel like I wasn't so crazy yesterday to be so confused. But I was very confused. So we've got instead canons of statutory construction, not just one little thing, but a ton of it, this is the way it is, weigh heavily in favor of returning the property to claimants notwithstanding such an appeal. In both, and we're getting two sections here, two pieces of OCGA, 5-6-34B and 5-6-45. Says the legislature provided that a notice of appeal shall act as a supersedious or shall serve as a supersedious. However, the legislature has not included any such language or otherwise identified any basis for staying the underlying order dismissing the complaint in the facts of this case. Courts presume that the legislature acts intentionally and uses language intentionally. They're citing here City of Atlanta v. City of College Park, which says, we apply the fundamental rules of statutory construction that require us to construe the state statute according to its terms, to give words their plain and ordinary meaning, and to avoid a construction that makes some language mere surplusage. At the same time, we must seek to effectuate the intent of the legislature. We must presume that the state statute was enacted by the legislature with full knowledge of the existing condition of the law and with reference to it. It is therefore to be construed in connection and in harmony with the existing law, and as part of a general and uniform system of jurisprudence, and its meaning and effect is to be determined in connection not only with the common law and the Constitution, but also with reference to other statutes and decisions of the court. Whereas here, the legislature uses certain language in one part of the statute and different language in another, the court assumes different meanings were intended. So accordingly, the state is ordered to return, what a beautiful thing to see, claimant's property to Mr. Williams or his designee by 5 p.m. Friday, January 9th, 2026. And for what it's worth, she gave them the heads up, like, hey, plan to be prepared to return his stuff on Friday. So, Jim, I just sent a link, just so you know. And then, yeah, allegedly, maybe we're going to find out what, if they have it all on Friday. So, and 5 p.m., you know, the state never likes to do things on time. They can't, but this isn't something that you can just e-file at 11:59. Like, this is physical property. And you've got to send an email to arrange how you're going to coordinate this if you're not going to do it. Like, this order isn't like, bring it to the court. So they've got to coordinate how to make this happen by then. And they were too lazy to send an email responding to an offer to get these transcripts for $208. Now they're going to have to work tomorrow because Thursday starts in 17 minutes, East Coast time. We're adding to the vocabulary today. Yeah, Happily Angry Lawyer says, my involvement in YSL, you got to be careful, in the YSL case, began entirely because of me thinking, surely I'm the idiot, this can't possibly be this stupid. And Hal, if you joined late, and I'm sure you probably read the motion on your own as soon as you saw it pop up, but in case you didn't, and you joined late, Whitaker said flat out that the court made misrepresentations. Well, she parentheticaled the miss just like Steele did. But I think that's a really important thing. We have Whitaker acknowledging that this prosecution team is making misrepresentations to her in something, an ancillary proceeding stemming from the YSL saga. So, loved that there. Yeah, allegedly maybe says don't catch a Rico here. Gotta be careful. And let's see. Roll One Up says they're going to make a low funds appeal. Like, please have mercy on us. We don't have the funds for this. I mean, you know what I hope happens? Do you guys remember that reporter who happens to be named Chase that was chasing down Fonnie Willis to ask the question of, like, I forget the exact prompt, but, like, what do you have to say to the taxpayers about the use of the funds and prosecuting this case? It's where we got this gem.
My message to taxpayers is it was an amazing time. We had 19 convictions. The community is safer. We made sure that we got the resolutions we want. If they're unhappy with sentencing, they should elect other judges.
Hold on, wait, one more clip just because I have it ready.
Adam Abadi, I thought, did an excellent job.
So, like, we need Chase. We need that same reporter It doesn't even need to be Fani. It could be anyone that worked on this forfeiture. It could be Grant Rood. I don't care. But someone ask, like, how did the civil forfeiture go for you? I just want to see how their response would go. So, yes, this one about, oh yeah, it was about the murders that took place, and yet they don't get convictions on these murders. They're willing to drop the remaining, there were like 3 remaining co-defendants for what would have been the YSL trial part 2. And then all of a sudden we were like, oh, there's plea deals. And then we find out that they reduced the murder charges to ag assault and didn't even call the family member of the victims before making that decision. Even though they consulted with them previously when they were trying to build a case and probably trying to get them to testify and get on the stand to do some type of sympathy pull character stuff that they're not supposed to be able to do, which isn't the family member's fault, but I'm saying that's the game that Fulton County seems to play. So, what is it, the math that Hal did that, I don't remember the exact numbers, but that Diamante Kendrick and Doug Weinstein, they were like over 100% acquittal in the case. So, good times all around. He's ready right in the chat. He says 111.1%. There we go. What a legend in the chat with these numbers. Happily Angry Lawyer, if you guys remember, started off as just a Jim R in the chat with a little gray icon. Like, you know, and I love Brooklyn, and I mean this with love. Brooklyn has the B, and Jim just used to have the J. He got so riled up. He's turning into his true form, out here fighting for Moongtoong. He's got other cases he's working on, and he's got all the math worked out. 10 wins, 9 counts. There you go. So there we go. And I could probably figure that out if I thought about it. I think we have Tomatoes. So the Adventure Aaron Tomatoes, destined to be, is joining in. I think that might have been from the Adam Abadi mention. Brooklyn, I didn't realize Brooklyn said this. I hope Ashley Merchant shows up Friday. Just why not? Just why not have Ashley just be there? Be like, hey, here to see if you're returning all the stuff. Because why not? The whole Gactyl team, just for the sake of it. So there we go, you guys. That is the motion. Oh, the order was prepared by Oh, that makes it better. With modifications by the court. So, it's not uncommon for the prevailing party to prepare the order. But I just love seeing this because as we read through it, Whitaker just kept all this stuff in. So, that actually, I think that's great. That is golden. Oh, goodness. Yes, and just Shamrock. And that's why when I mentioned McBurney earlier in the court and the Adam Abadi being the brunt of the joke, because Adam Abadi like was caught off guard and thought about it for a second and then realized what McBurney was talking about, and you could just see it play out. But McBurney made a quip after one case had ended and they were waiting for something to happen they could start talking about the next case. McBurney just goes, so I heard you got a Christmas bonus this year. And Abadi was just like, what? just got him stuck like a deer in headlights. Fatima, good to see you, says, what's going on with Moongtoong? So, waiting, and I forget the time frame, but I think end of April. And Jim's probably ready in the chat typing out the time frame. But since it's at the Court of Appeals level, and they have this odd window where they could do it anytime today until the end of the calendar session, you just got to check and see. So far, no updates from the Court of Appeals on what's going on with the Moongtoong appeal. And I think Jim's most recent, or not recent, but consistent prediction is it'll probably be something that gets remanded back down to the trial court, to Whitaker, which I think is just funnier now because I think Whitaker must be having this growing sense of the mess that went on with this YSL prosecution, this YSL indictment. And one of the major issues, as you guys all well know, with the Moongtoong thing that is still pervading the state's responses to Jim and Tiffany's briefs is they're still insisting that it's true and correct that Moongtoong had this like sex abuse charge or whatever, sex battery charge on his record just because the probation officer read it out in court, probably confusing him with a different person named Anthony Sledge. And for whatever reason, the state, like idiots, was just like, nah, it was correct. So, doesn't look good when you have, I don't know when that might happen, but this would be stuck in my brain, these misrepresentations. Sure, counsel for Mr. Williams might have prepared this, but the court adopted it. The court agreed that Fulton County made misrepresentations to the court. So, yes, and what's his name? Alex Burnick? So when we were looking at like the notices of appeal and whatever the state was filing in the civil forfeiture matter, Grant Rood and Alex Burnick were the signatories for the state. And Alex Burnick is, when we read that reply from Fulton County to Jim and Tiffany's appellate brief for Munktunk, Burnick was the one who prepared that that opposition, their brief. So, and yeah, okay, it is Alex. I don't know, sometimes I just mix first names up. So I remember Burnick was the last name. Like, am I making up the first name? But who cares? If I got the name wrong, it would just be the same as what we see with all these court dockets. What's changing a name? So, yeah, Fatima with all caps. You guys can do an all caps rant if you guys want. Fatima starts it off saying, I swear I can't do stupid, and the state is stupid 100. I agree. I'm with it on all counts. YP is here. Miss you, YP. This was a great time, YP. I think you'll enjoy this one, even if you got to rewind to get to it. Other than that, you guys, I mean, this was it. I mean, everything in this order. You saw me nod the whole time. I don't have anything. I've got nothing else. Everything that I would say is like written in here and written better than I would say it. So, and I still think it's so funny that this is so much of Steele and Leanne Webster's motion. And Whitaker's like, all right, got it. And you know what? Let me sprinkle in an extra footnote here. Let me address a new thing that, you know, wasn't ripe to address in the December 18th thing. But let me just sprinkle this footnote in here. In addition, this extra little burn. So Kimberly says, where is the watch? Where is the watch? Oh, man. Just crazy. And oh no, that's really sad news. There was a shooting, Kate. I always hate hearing that because it's like, sometimes I wonder, like, it can't just be because we're more tuned into the news. I just feel like sad, crazy stories just do happen more. And it's not just that we're seeing it more because we're interested in like law adjacent topics. So that's really sad. That's really sad. And at a funeral. No bueno. Some comic relief here, much needed. Erin says a few months ago I got bored and photoshopped Fani wearing Duke's chain and her driving in the Benz outside Rice Street. And I don't know if I saw this or if I can just picture it in my head. But I can picture it. Oh my goodness. Just crazy. Shouldn't be something that's easy to picture. Let's see, you guys. It is quite late. It is about to be Thursday, which means the state has a day and a half to get it together. The clock is ticking for the state. I see, let's see, Runkle of the Bailey is live doing, it looks like he's doing the Uvalde. They had the hearing today outside the presence of the jury, and he also has the Corey Richins hearing. So if you guys missed the Corey Richins hearing, I think it was pretty long. EDB was live for a long, I like took a nap and EDB was still live. If you missed that, Runkle seems to be talking about that. Potentially Criminal is doing a analysis of the Minneapolis ICE shooting with, was it murder or self-defense question analysis. Oh, Jim. Hold on, let me show you what I see here on YouTube chat. Let me load it and show it to you guys. Um, what is this, Jim? February 8th? Fix it, Jim. What do you mean February 8th? Everybody go pretend to wait a month for this. But yeah, I think Jim's going live tomorrow at 1 p.m. Eastern. But it says February. So there's that. Also, guys, let me give a shout out now that Lisa Figueroa is on the screen. I feel like I've been getting overwhelmed trying to keep up with all these different cases. And Lisa, her YouTube name is Florida Defense Team. But she's been doing these short, concise update videos on major cases. A lot happened to be in Florida. She is a practicing Florida attorney. But really like straight to the point, explanatory. Like she's going to explain the legal concepts in like layman's terms. Really, really like the coverage that she's doing on both the Alicia Andrews and the YNW Melly stuff. So just because I see her here, if you guys have not checked her out, it's like a new channel. So I think there's a good chance a lot of you guys haven't heard about her yet. So I'm just going to say Lisa and drop it in the chat. And remember, her channel name is actually Florida Defense Team. So if you've got to search for it, that's what you got to type. But yeah, we should appreciate Hal planning a month in ahead. You're way better with your timing than the state. Okay, the title is funny. You got the probably in there. I like a good parentheses. So there we go. Let me pick a redirect here. And you know what? I'm sorry, Ike. I'm looking over here and I saw your comments earlier, but not this one. Thank you for the super, and I'm sorry I missed it. Saying, is this like when your sister steals your jacket, loses it, wants compensation for what she left in the pockets, and somehow it's still your fault? Yeah. Is that a real story? Has that happened to you? But that's a very specific, but I think a very good comparison. And let me see. Let me pick a redirect. And when I do pick a redirect, this is going to end abruptly because we did the ABCs of Steel at the beginning. Let's see. YouTube Studio, a redirect. Let me drop the link to Ian. Let me do... Let's see. I wish YouTube made it easier to do redirects. You have to go through like 5 steps and then make sure you actually hit the save button, or I'll be like, we're gonna redirect. See you guys, bye. And then it won't actually take you guys anywhere. But you have to click twice for it to actually save and stick, which is stupid. Let's see. We'll do a redirect to potentially criminal. I mentioned yesterday Tabiz had a birthday celebration that's now going to be on the 9th. So maybe we can we can get over there and be like, happy birthday, and also see if Jeffrey Williams gets his stuff back. And then you guys know I love Hella Excited Utterance and Andrea Burkhart. They're supposed to be doing a collaboration together, I think, tomorrow. So I think they're going to be talking about the Delphi case. So those are just some things on my radar. This is not an exhaustive list. There's like so many people covering great things right now. But that's just some stuff to throw out there if you guys are looking for something. And let me get Ian's link. Because I've somewhat recently redirected to Ian. I don't think I've redirected to potentially criminal like ever, because I'm never live when he would be live. Ian Runkle. And then, yeah. Hopefully I don't have to go live tomorrow because the state files a stupid response, but if they file a stupid response, and they seem to file responses quickly when they lose and never do their homework when they're supposed to otherwise, I'll definitely go live and talk about whatever they complain about or say. All right, so there's Ian's link in the chat there, Ian Runkle. Thank you everyone for hanging out so late at night. I've got Hal sitting on the screen here. Good to see everybody as always. And yeah, let's hopefully not have to get together for the state trying to keep this going. But I'll see you guys wherever I see you next. Bye, guys.